Welcome to the program News from Poland, Business and Law, in which Sylwia Moreu-Żak, attorney at law, counsel at Wardyński & Partners, will discuss in a moment the topic of guarantee liability of the investor and the general contractor for the remuneration of subcontractors under construction works contracts. Later, I will explain how an unexpected combination of various economic events created at present very favorable conditions for funds investing in the private rented sector, PRS. We address our program to foreigners acting as board members in Polish companies, foreign investors in Poland, and their foreign advisors.
Hi. The investor and the general contractor are jointly and severally liable for subcontractors' remuneration due to them for construction work. This solution is unique to the Polish legal system and rarely encountered in other countries. It is a surprise to foreign investors just entering the Polish market who are concerned about possible negative financial consequences. Polish statutory provisions on investors' guarantee liability are strict and in practice often mean the risk of double payment for the same work, once to the general contractor and secondly to the subcontractor. These provisions became law in 2003 as a result of subcontractors repeatedly incurring losses when performing contracts, which often led to their bankruptcy. In 2017, these regulations were amended to prevent misinterpretation. However, our experience shows that this aim has not been achieved and that many questions still arise from the application of these regulations. What is even more difficult is that the previous rich case law cannot be directly applied. Participants in the construction process, including investors and general contractors, must adapt to the situation to prudently and effectively mitigate any possible risks. The main condition for the investor's guarantee liability is that he has knowledge of the scope of the subcontractor's work and has not objected to it. In this regard, the contractor must notify the investor about the detailed scope of work commissioned to a given subcontractor prior to commencing the work. The investor then has 30 days to object to this work being commissioned to the said subcontractor. The subcontractor can also submit the notification. If the investor does not object within 30 days, he will be deemed to have impliedly consented. Such written notification is not required if the construction work agreement describes the scope of work which is to be commissioned to a specific subcontractor. The investor's liability is limited to the amount of the subcontractor's contractual remuneration as determined in the subcontract agreement. However, it may not exceed this remuneration for the same scope of work as established in the agreement concluded between the investor and the contractor. Provisions on investor's guarantee liability also apply to the relationship between the general contractor and the subcontractor, and between the subcontractor and the further subcontractor. Foreign clients often ask, can a construction work agreement based on the provision of other jurisdictions exclude the liability of the investor? No, these statutory regulations cannot be excluded. This means that the liability of the investor cannot be regulated differently within the contract, and any contractual provisions contrary to these rules are invalid. It is also not possible to exclude the application on provisions of the investor's guarantee liability by choosing a foreign law in the agreement concluded by the investor with the general contractor. In the face of such strict regulations, investor can and should protect the interest at each of the three stages: contracting, notification of subcontractors, and contractor claims for payment. Most of all, they can protect themselves by including appropriate clauses in their contracts with general contractors, which is something we always encourage them to do. It is standard practice to require general contractors to provide written statements from the subcontractors that their receivables due and owing from contractors at the end of a given billing period have been paid. Failure to provide such a statement is grounds for withholding payment to the general contractor. Agreements should also specify the investor's right to pay remuneration due to subcontractors directly. Contractual set-off is a good way of recovering amounts paid directly to subcontractors. This should also be specified in the contract. Contractual penalties reserved for non-payment or late payment of remuneration to subcontractors are also effective. A more effective instrument for recovering amounts paid to subcontractors will be a bank or insurance guarantee, which should also secure claims for recovery of direct payments to subcontractors. Regulation or Polish court jurisprudence do not uniformly deal with the possibility of seeking recourse from the contractor. According to the strictest standpoint, without separate contractual stipulation, there is no recourse claim on the basis of the civil code alone. Opinions also prevail that the investor is entitled to a refund of half the payment made to the subcontractors, and some believe that he can claim for whole amount. For this reason, a contractual provision should provide the possibility to recover from the contractor the remuneration paid to the subcontractor. The contract may additionally stipulate that the contractor is obliged to reimburse the investor for other costs incurred in connection with the subcontractor's claims, such as courts of court proceedings, interests, legal fees. This will shift the risk of litigation with the subcontractor to the contractor and give the investor greater comfort in evaluating the subcontractor's claims.
In order to fight the rising inflation, the Monetary Policy Council has been raising interest rates from October 2021. The interest rate increases are intended to reduce the amount of money in consumers' wallets in order to curb the demand that inflation feeds on. These increases have doubled the amount of mortgage installments that borrowers have to pay off each month. Moreover, since May this year, when granting loans, banks must, in accordance with the recommendation of the Polish Financial Supervision Authority, assume higher costs of living for borrowers, especially families with children. The result of the above actions are a drastic reduction in the creditworthiness of Poles, a drop by several dozen % in the number of people applying for a loan to buy a flat, a situation in which renting a flat is cheaper than buying it, and of course, a large increase in the demand for apartments for rent. Such demand is strengthened by the fact that after Russia's attack on Ukraine, 1.5 million refugees came to Poland, some of whom rented apartments. All this creates excellent economic conditions in Poland for further development of PRS. Thank you for watching this episode. See you next time.